Hi, I'm Brad Willingham. I am doing a case study presentation for EDU 503. The case study that I chose was Menorah versus Illinois High School Association in 1982. A little bit about the case. It was between the high school, Illinois High School Association had a rule which the Illinois High School Association is a private association. They also oversee in parochial schools as well. And one of the rules that brought on this case was that they were forbidding basketball players from wearing hats or any other headwear except a headband width no wider than 2 inches while they are playing basketball. The main reason for prohibiting headwear, they stated it was because if it falls off while they were playing basketball, someone might trip or slip on it and injure themselves as a result of it being off their head. The plaintiffs in this case are two Orthodox Jewish high schools in Chicago. They were or are members of the interscholastic basketball team, and also the members' parents were under the category of being the plaintiffs. The plaintiffs claim that the rule of no headwear while playing basketball was an infringement of the religious freedom of Orthodox Jews. One of the rules for the Orthodox Jewish males are required by the religion to cover their heads at all times by wearing a hat called a yarmulke. And the only exceptions to not wearing these is if they're unconscious, immersed in water, or in some imminent danger or in danger of loss of life. Some of the case arguments were that the Illinois High School Association does want everyone to participate in playing basketball, but it wasn't in the best interest for everyone to allow athletes to play wearing headgear if it could possibly injure other players. The plaintiffs claim that the headgear rule forces them to choose between their religion or playing basketball. In this case, in Chicago, basketball for these two schools, basketball is the only sport that is available to these two schools for their students to participate in. During the proceedings, it was brought up that the association once had an exception to their headwear rules for soft barrettes, and the association repealed this during the course of the litigation going on, which was kind of strange. That the court kind of thought it was strange that they would repeal that, but it might have been for tactical reasons to win their case. And the exception was that the girls could wear soft barrettes which was pretty much the same thing would occur if a soft barrette fell out of someone's hair. It could also make someone trip. But the association tested that the main reason that they allowed soft barrettes was because it was more of safety to keep the hair out of the girls' eyes at the time, which would help them from avoiding collisions because they couldn't see. And they were saying that the yarmulke doesn't provide any protection of keeping people's hair out of their eyes. So it really didn't change the fact to the decision of the courts, but it was just one of those things that was kind of interesting that they had the exception for barrettes, but not for yarmulke, which I can understand. A barrette does, if you have long hair, if you got hair flopping around and getting in your eyes, you wouldn't be able to see. And a yarmulke just sits on the top of your head and doesn't really keep your hair out. Some of the court findings showed that the courts had to compare two burdens. The burden of the association was for them to having to change the rules in order to allow the athletes to play. The athletes not being able to participate in their only available sport because they practiced their religious beliefs. The courts came up with a conclusion and found that the yarmulkes are not the only thing that can be worn by Orthodox Jewish men. With a little bit of research, they found out that as long as it was something that covered their head, that could also be worn. Now, should they wear a yarmulke that has a strap around their neck? They weren't going to be the ones to decide that. They left it up to the Orthodox religion and the Jewish community to come up with another way to cover their heads that would not be a safety issue for other athletes while playing basketball. So since they know more about Jewish law than probably the courts do or the Illinois High School Association, they left it up to the Jewish community to come up with a way to still be able to cover the Jewish men's heads while they're playing basketball without it interfering with the actual playing of the basketball. The final decision that the courts decided on was to vacate and remand until there was further information provided by either one of the parties. Now, how this affects a athletic director in any situation is that a lot of times it's a real difficult thing to be able to, if someone's doing something for religious beliefs, it really can be a real sticky situation when it comes to saying that someone can't do anything, and that's exactly why because they thought it was impeding on their right to choose their own religion, and they shouldn't be able to have to choose between basketball and the religion. And so a lot of times, I don't know too many other really examples about that. Maybe we might have some situation where a athletic director might have to deal with prayer or something like that before a game or after a game. Someone might have a problem with that, but it is one of those things that you probably aren't going to come across a lot, but if you do, you have to be very careful how you deal with those situations, and hopefully that doesn't occur while you are an athletic administrator. That's pretty much it. Thank you.